Okay, now intellectual property, that's fun. I hope you guys, if you are interested in intellectual property, that you take the intellectual property class at Harper. But intellectual property is actually 3 specific protections. There's copyright protection, which copyright protection is grounded in the U.S. Constitution, and it covers original works of authorship fixed in a tangible medium of expression. So if I, just go on some sort of oratory kick and start spouting limericks or something like that, that's not copyright protection. But if I write down my limericks or somebody records my limericks, then that can be granted copyright protection. Okay, and it doesn't have to be published for you to get copyright. So if I just, write a little story, I can copyright it. So things that are covered by copyright would be literary, so books, short stories, dramatic, so plays and things like that, music, artistic works, poetries, novels, movies, songs, computer software, and architecture. Things that are not protected would be just a fact, idea, systems, methods of operation. But if you write, so like a bomb, that's not copyrightable. But if I write an article on how to build a bomb, that would be able to get copyright protection. It's different from patent or copyright. We'll talk about patent and trademark in a little bit. But the copyright protection actually occurs the second it is created and fixed in a tangible form. You don't have to register it with the Copyright Office, but if, say, you write something and you don't copyright it and somebody steals it from you and copyrights it, they have the presumption that it's theirs, and you have a burden of proving that you did it. So if this is something that you think of value, or you might be using it in a commercial setting, or you think it's marketable in a commercial setting, it's in your best interest to copyright it so that someone else doesn't steal it. To do copyright research, you go to the U.S. Copyright Office. 2 things you can do here is register your copyrights or search prior copyrights. Okay, copyright.gov is your website. Look, register, record, research. Very, very straightforward. So I'm just kind of looking and sometimes they change it a little bit. So if I want to record my own copyright document, I would go here. They have a lot of stuff that is helpful. Some FAQs. They will have, if I go to register a copyright, it's going to give me steps, and it's going to show me how to set up an account and give me registration processing times. Oh, well, that's a downloadable document, all sorts of stuff. It's going to give me checklists. It's going to give me law and guidance. $3.2 months. So 2 months if you don't require correspondence, and 4.4 months if you do. So that's how long it takes to get a copyright registration. So you can log in here, law and guidance. Here's forms, news stuff about them. So that's if you are actually going to be registering or copywriting something, and this would be, by type of copyrightable material. Okay, and record a document, and here's research. So I'm just going to go right here because it's right there. I'm going to search my copyright records. You want to see if something has already been copyrighted. Okay. So you can do it by title, by name, by keyword. So say let's do for Ernest Hemingway. If you do name, you do last name first for a person, and obviously company, you write out the company name. Okay, so here's a bunch of Hemingway titles. It's only giving me what do we have? 228 entries. It's only giving me the top 25 on this page. So say I want to find these Nick Adams stories, and I'll show you what a copyright registration does. Okay, so it just tells me what kind it is. It gives me a registration number and a date. And that's really it. The interesting thing about copyright is that it doesn't have to, there's no like examination process. It comes in, they give it a copyright number, they enter it all into the system, they download it, and that's it. Nobody's looking at it to see if it's been copyrighted before. So if there is a dispute and it's similar, they just say, first in time and is first in right there for copyrightable materials. So different from that are patents and trademarks. So patents and trademarks, before they are granted, they are examined by a patent examiner or a trademark examiner. And it is a legal proceeding, which may be time consuming. And if you are trying to patent something that's already been patented or trademark something that's already been trademarked, it may be denied. So that's the big difference between copyright and patents and trademarks. So trademarks are commercially based. So it's a word, letter, number, design, or combination thereof that identifies a party as the source of a particular goods or services. So it's like brand names, symbols, slogans. Think of like Coca-Cola, Nike, KFC, something like that. So the trademark examiner has to make sure that something you are trying to trademark, the mark, is not descriptive, generic, or likely to cause confusion. Okay, so descriptive. You are selling water and you want to call it water. Okay, so that is not like trademarkable if you just call it water. Or if you want to, register a cola product and you want to call it Coca-Rola or something like that, likely to cause confusion with an existing mark. If you want to just claim that you're going to trademark something, you can write TM or SM after the trademark, but that's called a non-registered mark. You're just saying, I am claiming this is mine, but I haven't done anything with the government. Registered, you've all seen this, the little R with a circle around it. That means that it is a registered trademark. You don't need to register your trademarks, but same thing, you might lose legal rights and protections, and someone else might decide to use it, and then they're going to win because they have a registered trademark. If you have registered something, you have the exclusive right to use it and a legal presumption of ownership, and you can sue others for unauthorized use of your trademark. And the way you register trademarks or search trademark stuff is at the U.S. Patent and Trademark Office website, which is uspto.gov. You'll have the option of going into either patents or trademarks and doing some searching. Are we there yet? Okay, so basics, timeline to process it. This is like super helpful for someone who is new to the intellectual property area. But do I need an attorney? What do I have? My timeline. It will have, what do I have to do? How do I renew this? Laws. How do I use this searching system? They have some nice resources here. Right? Fees, topics on fees, and they have kids and educators, and, if you're teaching, can learn about patents and trademarks. Patents and, trademarks. all this kind of fun stuff. Guidance documents, they'll have checklists and all of that good stuff. Okay, so I just want to search this TESS. They have it here? Well, maybe I'll just go here. So TESS, TESS, of course, is a government database, so it has to have an acronym, maybe not so catchy. But there's different ways to search. You can just do a word mark search, a word and design mark structured, or a word and design mark free form. So we'll go here. So we'll first just start with a word. Okay, so word search. Okay, so say I did Nike here, and I hit submit query. Okay, and so these are all the word marks that contain the word Nike. There's 168 records. I'm currently looking at 1 through 50. Some of them are live, you see that, and some of them haven't been updated, so they're considered dead. So if this is just Nike, I have a serial number, I have a registration number. It tells me it's a word mark and who owns it and all of that good stuff. So I can't use Nike myself. So that's a word mark. I want to go home. Oh, that's not really what I wanted to go. I just wanted to get to the first one again. Okay, let me go back to test. Sorry about that. Okay, so let's just do a word and or design mark. So I'm going to just do swoosh and submit my query. And then you'll have ones that not only have words, but they might have designs too. So let's try this. Prime pet. See if there's a swoosh in it. Oh, see, there's like a swoosh. So has more. So it's more technical filing a trademark application, especially one with a graphic, because you have to look at these trademark manuals and see what numbers need to be assigned to them. So they would have, a dog would have a certain number, and a swoosh would have a certain number, and cursive would have a certain number. So it's a little bit more technical, but that's how you search the TESS. Okay, so let me go next to, I don't want to do that. Patents. Okay, so patents are, the other ones are business ones. These are technical and scientific inventions, machines, manufacturing processes. If you guys watch Shark Tank, they always look for whether or not someone owns a patent on what they're trying to sell. The standard for it is that it must be new, useful, and non-obvious. And we go to the USPTO on the patent section. And patents, you really need someone to help you file for it. So step-by-step process, search them, applying them, for them, fees, it's more expensive, a lot of stuff there. So let me search patents here. Goodness gracious, I got the cat coming. Okay, so we're just going to do a quick search. Okay, I always like to try mousetrap. I don't know if my cat's trying to get in my office or out of my office. Okay, so you have a patent number, and you can pick one of these, and then I'll give you the information on how you're trapping the mouse here. An abstract gives you a big technical explanation of how it works, and then I always like to look at the images, which are down here. And you can see what the patent looks like. So this way, before you take the time to register a patent, you can see if it's been used by someone else, because as you know, one of the standards for patents is that it has to be new. Okay, so this is this mousetrap one, and then it tells, just a standard old mousetrap. Tells you what it looks like. It's kind of old. It's kind of new for a basic mousetrap, but I don't know what's different about it, or maybe it was an expired one that they had to renew. Okay, so that is patents. Why don't you work on the classwork for intellectual property, and I'm going to end part 2 of this video, and then we'll go on to deal with international labor, employment, and criminal law.